Uh, it's 3 o'clock. Do you want to? All right.
Call this meeting to order? Yes. It is 3 o'clock. We're going to call this special meeting into order, training going forward. Please take the roll.
Supervisor Howard? Present. Supervisor Short?
I'm here.
Chair Wilson?
Here.
For the minutes, I want to note that Supervisor Vorges and Supervisor Starkey are absent.
Thank you. Please go forward. Introduce yourself. Petty public comment. We have no public comment. Unless Randy has something to say.
I do.
Oh, sorry. Comment from the board.
I'm not the public, but I'm going to make a statement that it's disappointing that some of our fellow supervisors aren't here who requested this to happen, confirmed that they'd be here, and who need this training more than myself.
Thank you. Please go forward.
Scheme within California. And so this is a very brisk overview. And so let's go. So these are the 5 subject matters that we're going to cover today. The MMBA, collective bargaining. We'll discuss roles that elected officials have. And I'm not limiting it to just the Board of Supervisors, but all elected officials. We'll talk a little bit about the Brown Act, and then we'll end our day talking about conflicts of interest and how to avoid them. But on that section, I'm going to defer to your legal counsel, county counsel, for that, because that's a year-long coursework if we were going to look at this. And each of those could be a semester easily. So again, this is just a brief overview. Before I go any further, I have to give you my agency's admonition. I can't be quoted for any reason whatsoever, right? This presentation is only for information purposes and does not constitute legal advice or how the board or SMCS, the Public Employment Relations Board, or the State Mediation Conciliation Service would rule or have a position on anything. But I invite you to ask questions, and I'll give you the best answer that I can today. So we're looking at what is labor relations, and the quick answer to that is just the interactions between the employer, like the county, and its employees, and the employees through the exclusive representative, the unions or the specialty associations. Collective bargaining simply refers to the rights and responsibilities in the statutory scheme. Here for the county, it's the MMBA, which is also found in the government code. And then there are assorted relevant statutes and regulations that come into play. And then people always ask us what the current status is now, especially with what they're reading in the media about strikes and whatnot, and impending strikes coming up. Like I hear another Kaiser strike is imminent. It just depends. It really depends on what the economic circumstances are within a locale. Okay. And so I just want to give you a brief historical overview of what the collective bargaining and labor relations, how that has evolved in California. We always start out with the 1947 National Labor Relations Act. That's the granddaddy of them all. After World War II and the economy started taking off, the presidential administration decided to pass ground rules. I call them rules of conduct and how employers and employees would interact with one another. And then you have the Brown Act of 1961, which governs how public agencies make decisions as transparent and as public as possible. And then what we're talking about today, it was the Myers-Milius Act. It's gone through several different iterations. It's now the Myers-Milius Brown Act that you all affectionately call the MMBA. And what's funny here is the reason I highlighted it is even though it was enacted in 1968, it didn't come under a specific enforcement agency like PERB, the Public Employment Relations Board, until 2001. So prior to that, it was enforced through the trial court system, Superior Court, Appellate Court, and the California Supreme Court. Occasionally cases would go up through the federal system. The district courts throughout the state of California and then to the Ninth Circuit. And then we have really, I think, the most specific kind of statute for labor relations, which is the EERA that has to do with K-14 schools. And it spells out everything from when and where and how you start your bargaining cycle to how it will end for that cycle. The difference with the MMBA and the Educational Employment Relations Act is in the EERA, fact-finding is mandatory after impasse. In the MMBA, under AB 626, I believe, fact-finding is voluntary, and it's the union or the employee organization that has to request fact-finding. But fact-finding is always just an advisory report that the committee will issue to try to break the dispute, break the impasse. Okay. And then the last one that's big on PERB's radar is the DILS Act, the state employees. I would say between the MMBA, the schools, K-14, plus the higher education, universities and colleges, and the state employees, that's 90% of what we do, what PERB enforces and SMCS tries to mediate. There are some of the statutes that fall under the Public Employment Relations Board to the right of the slide. Currently, there are 17, and in the next 3 to 4 years, we anticipate going from 17 to 30. That's what we hear from the legislature, and most of them are going to be transit districts that currently are under the public Utilities Commission, the PUC. They'll transfer over to HERB. So talking about the Myers, Milius, and Brown Act. So here are some highlights. Here's some highlights for the MMBA. The key principle is that there should be a free exchange of ideas, concepts, opinions, and proposals to try to ensure that an agency is working at its optimum best as far as productivity and for the community in providing services. The big picture ideas that we always like to enforce is the scope of representation. The MMBA is limited strictly to matters of wages, hours, and working conditions. Wages and hours are easy, right? They're definable. It's that third prong, other conditions of employment. And I'm going to give you a war story real quick. Prior to coming to SMCS, full disclosure, I was a lawyer for a public sector union. And one of the funniest things that ever happened in my career was, would you think that a vending machine changing the price from 25 cents for a Coke to 35 cents would be a mandatory subject of bargaining? But the circumstances were these vending machines were in a locked facility, a jail where correctional officers work, and there were other things going on. This was just one of those, we throw it against the wall to see what sticks complaints. And that was the one that got traction because you had employees who couldn't leave the facility. It had to do with what the court thought was nourishment. So that was a mandatory subject of bargaining. And so at that point, being a young lawyer, I thought, that's it, I'm done. I can walk away. I dropped the mic. So, but that's how crazy things can get when you talk about this. As you know, the duty to meet and confer, it's mandatory subjects of bargaining. There's also permissive subjects, right, that you can discuss. The duty to meet and confer is synonymous with the duty, the legal duty to negotiate under the MMBA. We have something that we call the meet and consult, right? That just means that you have to give notice about an employer, a management right that you're going to exercise. You just need to give the union or exclusive representative notice of this change and to consult with them. Again, freely exchanging ideas for an effective work site. And then there's the meet and discuss. And that's usually where there's a change in policy that's clearly within the purview of the employer, right? You're going to hear, all you have to do is give the exclusive representative, you just have to give them notice of the change and hear them out. Okay, there doesn't have to be a real dialogue. Right? And then the prohibition against discrimination, that's founded in the Constitution, the state Constitution, and that applies to everyone. So the MMBA, we would say, from SMCS's point of view, that there are three parties in that statute: the employees, the employers, and then the unions, the exclusive representatives or associations, right? Each of them has a duty under the act to negotiate in good faith. Each of them has a prohibition against discriminating for participating or choosing not to participate in a protected union activity. Sorry. And there's an additional duty for the unions to provide fair representation to all bargaining unit members, whether they are an actual card holding member or simply a member because they're an employee of the county and the bargaining unit that they represent. If this is too pedestrian, please let me know and we'll keep on moving quickly through this. Any questions up to this point?
I do have one.
Yes, sir.
Do you have any, on your last slide, do you have any, maybe examples of meet and consult or meet and discuss? Where would those situations be? Could you give an example of a meet and discuss situation or a meet and consult situation?
Let's talk about work hours. Okay. Let's say in the assessor's office, the typical work hours are 8 to 5, Monday through Friday. And if you're going to change those hours, right, to provide what the county would say is heightened services, maybe to a 980, 9-hour workday rather than an 8-hour workday with a every other Friday or Monday, whatever, off, that would be a mandatory subject of negotiations. So that's a duty to negotiate. Now, as public employees, they're entitled to an uninterrupted meal break and breaks during the day, right, during their 8-hour day. If the manager wanted to schedule different staggered lunch hours, staggered break times, right, that would be a meet and consult. Because that's within management rights under the contract that the county can dictate the hours, right? They can't change the 8 to 5, but they can dictate what happens within those hours, right? So that would be a meet and consult, okay? If in the assessor's office, if they were behind in paperwork for one section or another, right? And they were going to move people to that other section to help temporarily get them caught up. That's a meet and discuss in our view, because you're giving the employees notice that they're going to be doing a temporary assignment, and assignments clearly is within the prerogative of management, right? And if they went yelling and screaming, they still would have to obey the directive to go help out that section. So, Board Member Short, did that answer your questions? Thank you for that question. Anything else? Okay, so the MMBA really is heavy towards setting out rights for employees, right? They have the right to organize into a bargaining unit with common interests. They have a right to pick their representative. And what this slide is trying to show is that's all put in the government code sections 3500 to 3511. And it's a spattering of those rights. It's not delineated 1, 2, 3, 4, 5, right? And so even though the local agency can pass rules to develop a appropriate bargaining unit, again, they have common interest, and then there are some that are so unique, like your deputy sheriffs, right? They have their own bargaining unit as set forth in the Police Officer Bill of Rights, POBAR. But once that bargaining unit is set by the county, that bargaining unit gets to pick whom they want to represent them. They can represent themselves as an association, elect their own officers, or they can bring in a professional representative group, maybe like SEIU, PORAC. So they get to determine who their exclusive representative is. Now, I was trying to look through your codes, and I didn't see that there was anything particular about elections for exclusive representatives. So I think the fallback then falls on the MMBA. And on the MMBA, it's in order for a unit to, or for an organization to become the exclusive representative, they first have to show 30% interest of support. And then if they have 30% interest of support, then they can ask your labor relations. I know you're hiring for a human resources director now, but they would probably go to the CAO at this point and ask for an election, right? And within 10 days of requesting that election, there's got to be a posting, right? And another organization or any organization can come in and challenge that petitioning organization to become the representative. And so you have it easy. Under the MMBA, it's the winner is whoever gets the majority of votes that are cast. In more arcane jurisdictions, their labor relations ordinances say that it's got to be a majority of the entire bargaining unit. So if you have a unit that has 100 and only 49 vote, the majority has to be 51. No one's ever going to win because they never get enough votes out. And then in an even weirder situation, they say that there are some jurisdictions that require a majority of votes, but that majority of votes has to be one more than the total number of FTEs associated with this bargaining unit. So if there are, again, 100 FTEs, but you're 25 you have 25 vacancies, that could skew the whole election. And I will tell you that's happened in the San Diego area. So, what, yeah, well, I think the legislative intent was to just say that a showing of a third, that would be an interest. The situations I'm talking about where we're talking about FTE, do all the FTEs have to vote, or a majority of FTEs, or a majority of bargaining unit members? Those are local rules. They adopted even stricter than the MMBA. I can't answer what the legislative intent was, why they set it at 30. Yeah, and remember, Board Member Howard, that's only to petition for an election. That doesn't mean that that organization will win. At least they have some showing that a third of the unit at least is initially showing them. Yeah, and that's happening throughout the state of California, that people are retiring out, and so there's a new influx of leaders that they see. Thank you, Chair Wilson. This next one is about, I just bring up about impasses and strikes, and what happens when you go to impasse, right? As I mentioned before, in the collective bargaining scheme under the MMBA, there's an option for what they call fact-finding, where it's like a mini trial, where each side will present their pros and cons for their last, best, and final positions. And an independent committee will write a report about how they think, and it's an advisory report, how they think the dispute can be resolved. Okay? Members of that committee are 3. One is appointed by the county, the other one's appointed by the exclusive representative, and the third is a neutral chair. You can either pick the chair or mutually agree to a chair, or roll the dice and see what name comes up on the wheel from the Public Employment Relations Board's list. Again, fact-finding will only go forward if the union or the employee organization asks for fact-finding. Teamsters is notorious for never asking for fact-finding because they don't want an advisory report, because in their mind, their position is well-founded, and they don't need someone else to bolster them up. Which I've told our Teamster constituents, just a blanket like that, I think, stops the ability to at least talk about a possible resolution, right? And so, again, June Peyoyo's opinion, in case anyone out there is listening. And then after that fact-finding hearing, I call it a hearing, there's 10 days, a cooling off period of 10 days before that report is published. So that gives the parties another opportunity to find a resolution using that report that you know is going to become public. Something that's a hot topic right now are sympathy strikes. If a sister bargaining unit goes on strike, do the other bargaining units cross the line? I know that looking at your contracts, it says they don't have a right to strike once a contract is in place. So that would cover the sympathy strike. But I will tell you that there are a lot of bargaining units that refuse to cross the line. And a lot of that's being litigated now within PERB. A lot of it is from the schools, where either the classified units go on strike and the teachers refuse to cross the line. That's what happened down in Southern California. And the opposite happened up here in the Sacramento area, where the teachers went on strike and the classified units refused to cross the line. Bus drivers, custodians, and the like. Don't know if we've seen it happen lately under the MMBA. This past summer, we saw it with the higher education. With the universities and colleges, where student teachers went on strike, and full-time faculty and adjunct faculty refused to teach classes. So, and then we always point out that the right to strike is not found in any statute. It's a creature of case law, of common law. All you'll find in the statute is how to try to prevent it. Safety because of the necessity is prevented from going on strike. That's correct. And then, hospitals fall into that area, and I think they're the cutting edge of what we call line passes, where the employer, the hospital, will let a vast majority of the employees go on strike without contesting that, as long as the essential employees show up so that medical services are provided. And we're seeing a lot of that now transfer to there are some jails that are manned by correctional officers who are not considered safety personnel, right? And so we're seeing line passes work in those situations. Okay. And so we talked about the scheme as it goes through bargaining to impasse. But what happens if one side says the other violated the MMBA by refusing to meet, to negotiate in good faith? Well, that, my friends, is called an unfair practice charge. The offended party can file a...
Jude, if you don't mind, I've just been given notice that people who are watching this online cannot hear the board when they're speaking, and ask that they speak into their microphones if they could.
And I guess I have to ask, is this being recorded?
It's being streamed. We have a YouTube channel.
Okay.
There seemed to be some enthusiasm amongst staff, and particularly department heads, to get this type of information.
So on those viewing remotely, are they able to ask questions?
No,
Okay,
it's just a stream.
okay. And so, getting back to filing an unfair practice charge, it is the Public Employment Relations Board, PERB, that enforces the MMBA. And real quick, the way that the organization is comprised is, it's a quasi-judicial branch of the executive branch. There are 5 board members, and in October, we'll be getting our 5th board member. We haven't had a full complement of board members for at least 7 years. So we will have 5. Now, when you file a PERB charge, the notoriety was you wouldn't see a decision for 2 or 3 years. Since 2018, the board has made a concerted effort to process unfair labor charges more efficiently. And so in 2018, at the height, there were 600 charges that were in the queue. Today, as of yesterday, I was informed that there are less than 150. So they've cut that wait time down tremendously. A lot of it has to do with the administrative law division. We now have 11 judges in 3 offices: Los Angeles, Sacramento, and San Francisco. Or it's Oakland, but we call it the San Francisco office, to hear cases. General Counsel's office, they're the initial branch that investigates an unfair labor charge, and the investigating agent will decide whether or not to issue a complaint based on her or his investigation. And then you have SMCS. We're a separate and independent arm of PERB, and our job is to try to resolve disputes before they rise to an impasse or an unfair labor practice.
Who makes up the board, and how are they seated?
They are seated by appointment, and they come from. So one of them right now is a former president of IAFF. Another one comes from a management law firm that dealt strictly with from the management's position. So the governor tries to appoint an even number, but I'm sure whether you're a Democrat or Republican, depending on who the governor is, that comes into play.
But it's a gubernatorial.
It is a gubernatorial appointment and a Senate confirmation. Okay. This slide just shows you how PERB breaks up the state. Region 2 is our Sacramento, which we also call our headquarters office. And like I said, the SFRO, the San Francisco Regional Office, is housed in the State Building in Oakland. And then the Los Angeles office is in Glendale. And then I'm just giving you a quick view here of the different statutes that come under PERB's jurisdiction. These are the big five. We handle the courts. The Child Providers Act is in flux right now, as you know, with IHSS workers. What we hear is there is going to be a joint powers authority, a statewide authority. But again, that's still in the legislature and how they want to handle that. So we're just playing it by ear. And then a lot of the transit authorities are coming over to PERB from the Public Utilities Commission. And then the division I work for, the California State Mediation Conciliation Service, there's only 11 of us. That includes our director that handles all of those statutes. And we are on the front end to try to block anything from going up to or escalating up to PERB's attention. And we still make house calls. We come to you, you don't have to come to us. And so our core services, our impasses, we handle grievances, even uniform complaints, employee against employee complaints. And we administer public agency elections. Something new that's been happening and we've been using along the Central Coast is what we call pre-impasse interventions. That's when groups have one or two issues that they believe is solvable, but they would just like to be able to discuss them in a no harm, no foul mediation proceeding. Because mediation is a confidential hearing or proceeding, and what's said in mediation can't be repeated outside of the participants. So the chief negotiators can talk with one another bluntly, right? With the mediator acting as a referee and facilitating those discussions. And that's caught on for us in resolving issues. We also provide what we call ancillary services, and these services are like conflict resolution in the workforce, which is really a marriage counseling session between disputants, between coworkers or subordinates and their managers. And then from time to time, we administer private elections. Since our national counterpart, the Federal Mediation Conciliation Service, has stepped away from doing card checks, has stepped away from administering elections for one reason or another. And those services we bill, nominal is what I'm told, $115 an hour. I guess if you hired someone privately to administer an election, I'm hearing that runs at $500 an hour. So I think we're on the cheaper end as our service.
Just a question.
Yes, sir.
And does the mediation organization also deal with POBAR?
We do.
Okay.
We do. And I was remiss in giving you my background. I did tell you that I once was a union lawyer. Prior to that, I was a police officer, robbery homicide detective in Southern California. So I'm the one who usually draws the short stick when we're dealing with safety. And the firefighters hate me because, you know, they see me coming in with my blue tie instead of a red tie. So, these are our 10 mediators at the moment. And because there's only 10 of us, we mostly work out of our homes as the base and go wherever we're needed throughout the state. And I just give you the regions of where people are from, so that way you get an idea of who you might get because they live in your area. But as you can tell, I'm from the Central Valley, and I'm here meeting with you folks. Next week I'll be in San Diego. So we go where we're needed, which is great for my wanderlust. Okay, getting back to the unfair practice charge. These are the general steps. When someone, maybe the county, files an unfair practice charge against one of its labor partners, the general counsel's office opens a case and starts the initial review and investigation. And then they try to settle the case if the parties are amenable, right? People file charges. Anyone can file a charge. It's whether or not it has the meat to be proven up when they are tasked. And so that's why there's that informal settlement conference. The general counsel's office calls it an informal. So if they call you up asking if you want an informal, it's a settlement conference. And then if they can't get it settled, then it goes before an administrative law judge who issues a proposed decision that can be appealed to the board. And any decision by the board is reviewable by the courts. And so we've developed a case flow, a flow chart of how this happens. I will tell you that the investigating agent files the complaint, then she or he is replaced by another attorney to try to settle the case. So you get a different attorney than the one who issued the complaint. On the lower part of this flow chart, if an ALJ case is not appealed, it only applies to the disputants, the employer and the employee organization. It is non-precedential. It's just for those set of circumstances and those parties only. If it is appealed and the board reviews the case, that's when a case could be precedent setting. having an effect on all similar cases. Similar facts, similar issues.
Now, I know for many initial complaints, whether they're inside or outside organization, there are timelines and limitations as to when the complaint is to be addressed, how notification to the employee and the investigation, et cetera. Are there any timelines within this structure?
There are. And I'm not prepared to tell you what all of those are. They're within the PERB regulations, which I'm sure your legal counsel can tell you is about this thick to look at the deadlines. And I don't want to misspeak, especially I have people out there listening who can't ask a question or correct me if I misstate something. Okay. Sorry about that, Chair Wilson.
No, it's just that I know for myself and organizationally, those time limits, those triggers are somewhat problematic, to meet and to get, especially within an organization, depending on the nature of the original complaint. And so having those triggers and having those timelines, just being aware of them, and if they do exist, just having within our policy and process, that recognition that and for the public to know that, this is not get it and forget it type of process, that there are requirements that are triggers that require your local government to act in a judicious manner and sometimes expeditious manner in order to, one, notify the individual employee, but also that there is a timeline result that must be met by us organizationally as we go forward within the investigation.
Yes, sir. And I can tell you, just off the top of my head, I know that the shortest timelines is a 5 business day timeline. There are many 10-day timelines, and then there's a 180-day calendar day timeline on the outside. So that's the highest that I just off the top of my head that I can think of. Most timelines are 10 business days, 30 calendar days, but there are some that go as short as 5 business days.
And it's problematic. It has been problematic in the past. I don't see that changing as we move forward, where one of the biggest hurdles on meeting those timelines has always been finding the legal representation or whether it was, semi-professional or an actual attorney to make and be present at those initial interviews and discussions within that timeline. And it becomes very problematic because you have to work through that with the employee in that process, and it delays oftentimes finding critical information at the needed time. Having worked in law enforcement most of my life, so but it is problematic, especially trying to find those critical as those resources get limited or get stretched out, having them be available within the time constraints that are put upon us within the system.
Absolutely. Anything else about timelines? So here's a brief overview of the collective bargaining system in the state of California. And so we mentioned the MMBA. Something that also affects county employees is wages and hours through the Fair Labor and Standards Act. And in those wages and hours, the Department of Industrial Relations, Standard Labor Enforcement Manual addresses a lot of hours, compensation, overtime, and that's that is enforced by the Labor Commissioner and also the Office of Civil Rights. I just wanted to touch base real quick on the merit system, right? This county, I believe, and please correct me, but I think this county is a approved local merit system. No. So, oh, I'm sorry. It's an interagency system that you rely on the state to administer. Okay. Okay. And so I just wanted to point that out. Do I need to go in depth about that? I have some information about it. I was looking also at your county personnel ordinance and your personnel manuals. But really, I think the collective bargaining in this county, the majority of it is with your actual MOUs with the bargaining units. And the fallback positions are the state resources, the MMBA and the merit system. And so Mackenzie has this PowerPoint if you want to look at it, and I'm sure she can load it up for everyone to access. I just want to give you a warning that SMCS doesn't always give our PowerPoints out for future use because the labor field is ever changing, right? And so we never want something with our logo out there that might have outdated and inaccurate information. So that's just our warning that the information provided in this PowerPoint is only as good as the presentation date of today. And so, again, this is just information about the merit system. You know, it's just to make sure that there is a transparent hiring process and promotion process to make sure or to do away with, I call the good old boy cronyism, backroom deals, favoritism. And so that's why it's there. And then the labor contracts are all online through the states, through the county's website. And I just have that there if anyone wants to look, since this is a public hearing, as well as the county code and administrative manual that governs personnel dealings. And folks, we've been going at this for an hour, so maybe a quick 10-minute break with leave of the chair.
We shall do it.
Okay.
Short 10-minute break. Five. We want to get this
5 minute
over.
break.
5 minutes.
Okay.
That's my favorite part.
Bringing this back into session, and after our 5-minute break, and we'll give you the floor.
Thank you, Thank you, Chair Wilson. And so the role that you play in a collective bargaining process, for me, really is based on the organizational chart, right? The County Board of Supervisors sets policies. And then the administrative office, CAO and staff, implement those policies in the daily operations, right? And then your department heads, and I divided your department heads into 2 sections, the elected and the appointed. Even though the elected department heads have some independence, the daily operation still has to go through the CAO's office because the money flows from the Board of Supervisors in the allocations, right? You guys hold the purse, and then the management negotiation team in this org chart answers to the CAO and his staff, because they're the ones who are implementing the board's policies, and they have to be mindful of the needs of each department, right? Whether that department is a general fund department that's fully funded by the County of Supervisors or by the county, or an enterprise fund, which is usually an appointed department head. So that, in a nutshell, is roles for the electeds in negotiations. And of course, the negotiations team have to be subject matter experts, right? In dealing with the labor partners, and they can bring in subject matter experts on working conditions when needed from the other departments. But it all comes down to the board is the final voice, because the board is empowered to accept, reject, or suggest a modification to any agreement with its labor partners. So these next 2 slides, these are unsolicited practice pointers strictly from June Payoyo and his observations over the past 10 years in SMCS. And what you pick up, you see a lot of different things. And so for elected officials, I think these general concepts would serve you well. So the first one is, during a negotiation cycle, deliberate in closed sessions and speak with one voice in public. I'll let you all look at them to see if you have any questions. And a lot of it is avoid putting yourself as a elected official in a situation where you're making decisions on your own instead as a governing body. You have your vote when you all deliberate, but you can't speak for any others.
My apologies. And this is just not with the represented bargaining unit. This could also be interpreted through contact with a member of a department per se, or somebody who, an employee that is necessarily maybe has a personal relationship with one of our board members, but has an interest in the outcome of what we may be discussing in bargaining in the future, those kind of conversations would essentially fall into some of this unsolicited pointers, I'm assuming.
Yes, your individual employees, along with their exclusive representatives, have the right to lobby you folks to express their positions, right? That right to lobby doesn't extend to eliciting promises from elected officials that then are going to be held as the decision of the full final board. Just as unions, their negotiations team gets the best deal that they can with their employer. As a democratic organization, they still have to go back and vote, get a ratification vote that the majority of the bargaining unit is willing to accept that tentative agreement. And you folks, as a governing body, have the right to adopt or not.
Communication that potentially takes place outside our negotiation team, that is basically a team that is identified in our policies and procedures. Those communications that a full board potentially has not heard until it comes to us in closed session, where these conversations about potentially what we may or may not vote on collectively and speak with, as one voice has pointed out here, how should we be treating those type of conversations?
So board member Howard, that's a difficult question to answer. And the reason I'm hesitant is because one shoe doesn't fit all, right? It depends on the time, circumstances, and what's being discussed, right? You can always have, like I said, the union can always lobby. They have the right to lobby their officials, just like any citizen of the county has a right to contact a board member and express their concerns or their points of view, right? It's called direct dealing. That's the violation, where as an elected official, you hear what the lobbyist is saying, and then you give them a promise to resolve that. That's direct dealing, instead of going through your negotiations team that's representing the interests of the county. You've just circumvented that negotiations team. And you've committed the entire governing board to a promise that may not be enforceable. Does that answer your question?
It does. Yes, it does, very much so.
Okay. Staff, do you guys want to weigh in, or?
So the key piece of that is making that promise, right?
Absolutely,
I mean,
Member Short.
you could talk to staff if you had a area where had an issue and say, hey, we're going to bring it to the board and we're going to discuss it and we'll see what comes out of it. And that's not necessarily negotiating in bad faith or doing anything wrong. Is that correct?
Under those circumstances, I would say yes.
However, I think Supervisor Short, this is, as you say in the title of your slide, upcoming bargaining cycles. upcoming bargaining cycles really start occurring after the board's passed a tentative draft budget, which basically is our first meeting in July, or second meeting in July. That way we know basically what kind of cash flow we have, or at least directing our bargaining team to bargain with, because the board holds the purse strings, as you so eloquently stated. The important piece of, until we know that, it's very tough to make some assumptions, promises, which we cannot do, but assumptions that we could even address the issue. And that's why we, with our policy and procedures, keep a negotiation team in place. So the communication takes a direct channel back to the board, and the full board hears that proposal all at the same time, instead of bypassing a process potentially that has gone through months of negotiation between the department head and the negotiation team that sets that department head's budget based on our policies and procedures. I think potentially the direct bargaining where we have conflict, at least the way I've seen it in the past, is if an employee from a department, let's say, directly contacts one of us, and then we bypass the process and bring that issue straight to the board without even going through our negotiation team. To me, that sets this board up to react to something before we even know potentially what our approved budget is for a given year and those department head wishes. So those are the kind of things that I really am very interested in today, and ensuring that this board, at least moving forward, tries to avoid.
Yeah, and I'm going to put you back to our organization
Oh, very good.
board, is because the board sets the policies, right? The direction that the county is going to go. It's the CAO and his staff, the department heads, that implement that policy in the day-to-day. So if I'm hearing correctly, if an employee comes to one of you as the Board of Supervisors and says that this is not working, right? We would like to see it changed, right? You listen, but you always point them back to the day-to-day operations is the purview of the county administrative office, right? That doesn't prevent you from having a conversation with staff about the concerns that you've heard, right? But as a group, you're the ones who set the policy. And if you, as a group, believe that a policy does need to be changed based on what you hear, then that's what happens. But the day-to-day operations is you have delegated that to your department heads and the CAO as the lead. Did that answer your question?
It does.
And one of the key points, and I think you Supervisor Chris Howard has skirted that a little bit, not intentionally, but just in his questions has touched on it. But for me, the main point is your first topic on that, which is these types of discussions should be closed session discussions, and that as much as possible, the board should show a unified front, especially engaging in labor negotiations and discussions around labor, primarily because it sends the wrong message and undermines the structure that we're looking at right now.
Sure. And let's face it, a governing board is about group dynamics of individuals, right? And the more contentious the issue, the harder it is to stay as a team, right? But that's why you guys get paid the big bucks to deal with that.
Let me know when that happens.
Yeah.
Funny guy.
Yeah, I guess where I was going with my comment was that in those situations, we weren't breaking any labor laws by doing those kind of things, whether we upset policy or this and that could be discussed in another forum, I suppose, but just as far as the Brown Act or any other labor laws, and I don't believe in that context there was any negotiation in bad faith or the other there was no unfair practices that were conducted just by having those conversations and saying, hey, I think we should discuss it.
Yeah.
Keying on that, that no promises were made was I guess where I was going.
Yeah. And bear with me, as an old Marine, we always said we disagree in private, publicly we lead in unison. And so I think that little adage might apply.
I think the importance of Supervisor's short statement is, and the importance of this training today is that you had a slide up here with a whole host of statute, and God knows we don't know all of it. Me being the longest tenured person here, I maybe know a quarter of it, and which is why we have policies and procedures in place, which we just adopted and enacted as of new last year, that really guide how this process takes place. And it's to avoid situations that might allow bargaining in public without a unified voice. And so I guess that's my biggest concern, is ensuring that when we come to the floor as we do behind this dais, we do it with a collective voice that is settled prior to coming to this dais in closed session as stated. And I think that's the most important piece.
And again, these are just practice pointers that I picked up in my 10 years as a neutral and independent party, and this is something that I think is helpful as principles, as guidelines, right? You guys pick and choose what you want to take to heart. So our next section is the summary of the Brown Act. And I'm sure you folks know this by heart. We're just going to look at the application. It's a legislative body. This county board is a legislative body. And we just want to highlight that it's also your subcommittees and commissions that you appoint that it applies, the Brown Act applies to. And so meetings, you have basically two different kinds: a regular meeting, which is scheduled at the same time, same date, same place, and then you have special meetings. And so your agendas have to be posted. And you can only act on items that are on the agenda, with these few exceptions. Public comment? Oh, sure. Just the public comment is required. And limitations on that public comment. And then as part of being transparent and open, any documents that you review or use has to be provided for inspection. Just curious, when in the streaming on YouTube, are people able to record off of YouTube? Off of your stream?
Close it.
And we're talking about closed sessions. And these are just examples of some things you might take into a closed session. And after every closed session, you have to report out. This is the important part of closed session, is the confidentiality. And that's why courts not look suspiciously, but they look at closed sessions with a very narrow view, because those are discussions outside of the public venue. And not that you need this reminder, but violating confidentiality under the Brown Act is a misdemeanor. But there has to be a willingness, a knowledge that you're doing this in violation of the Brown Act. Before we go to conflicts of interest for a brief overview, any questions about the Brown Act? Comments? Something I might have missed? It is. It is, and it's just a quick reminder as part of the ethics training. It's a form 700 that you fill out every year. You know.
That's a good question. Can we get you to sign us off on our 1, 2, 3, 4? Jackie says no.
Yeah. And so I'll just go through this quickly since you're going to have that training. Is that the granddaddy of the in California is the Political Reform Act of 1974. It's codified at Government Code Section 8100. Created the Fair Political Practices Commission, affectionately known as the FPPC, and their regulations are found at CCR sections 18110. Right? And then you have to look at the whole idea is avoiding any impropriety or appearance of impropriety. Right? That's the whole goal of these conflicts of interest law, that you're not abusing your position as an elected official. And besides the first two that I talked about, there's a string of court cases that talk about avoiding conflicts of interest or what could be a conflict of interest. And then, you know this well, your local conflict of interest code that you have somewhere in your county ordinance resolution or another document. Here are the general rules. And really it focuses a lot on self-dealing, making decisions that you will personally or your immediate family will benefit. And you'll get this in your training, you know that 3 ways to prevent a conflict of interest is the Form 700, where you identify and fully disclose all your financial interests. And then the next slide will talk about give you examples of the different types of financial interests that may cause a conflict. And then the third part is really the legalese of whether or not you did commit a breach of your office by engaging in confidential or in a conflict of interest. And I'm going to leave that up to your training and to your legal counsel to advise you on that. So, again, non-exhaustive list of areas where that conflict of interest could arise. There are more, but these 8 areas are typically addressed in the Form 700 that you fill out, and that pamphlet that you read so many years ago that you might want to just review. And so, folks, in these last 2 hours, we made that race through the MMBA, through conflicts of interest, through roles of elected officials, through labor relations in California and the scheme. So with that, I'm done unless you have any questions that I can try to answer. I also left my email address up there, and that plus delta is, if you get a chance, we always try to improve our training programs, and we tailored this one specifically for you. So let us know if there's anything that we did well, but more importantly, if there's anything that you would like to see changed. Right? If we do come back to provide similar training, we want to always make sure that we improve. And so the big one for us is the changes. How can we improve?
Did you happen to review our policies and procedures as it discusses collective bargaining before you presented today?
I would say yes,
Okay.
but not in depth.
Okay. Yeah. I guess my question is, I'm happy that you at least took a skim at it. And my question follow-up would have been, is there anything in there that you would recommend or see changing based on what we've currently got in there?
So to answer that intelligently, I think we would need more time.
Okay.
And I would need to be able to reference things. And again, it's just based on my survey of when I'm making house calls, right? And seeing how some people do things, how other people do things that might help you improve and promote labor relations. but I don't live here. I don't know labor relations is an individual personality from person to person, group to group, and I don't know those intricacies. So any suggestions that I might make are completely sterile from a procedural point of view. I would say though, that you should always have in grievances a mediation stage, so that way you can bluntly speak with one another under the umbrella of the mediation confidentiality. So that way you can be brutally honest with your counterparts and even with your team members about how can we solve this problem and how can we make sure it doesn't fester into something bigger. That's just my point of view. Obviously, it's biased because I would like to talk things out, but that's my initial one.
Yeah, I can understand, I think, the statement you make as it references personalities in a process. And there's a lot of personalities in small towns like ours. Everybody knows everybody, so everybody feels comfortable in approaching potentially their elected officials. But I think even more so because of that, ensuring that elected members in particular follow the policies and procedures in front of them, especially as it relates to collective bargaining, helps to avoid some of those personalities that may arise and allows us to stay together on one page.
Yeah, building a system.
Yep.
Building a system for
And that's
perpetuity.
really why I asked the question, have you taken a look at it and do you feel any necessary changes? And so maybe at some later date, if the time does allow, please, if you could, take a look at it.
Sure.
I'd appreciate it.
I will say nothing glaring that jumped out at me.
I would hope not, because we just went through this a year ago.
Okay. Well, thank you for inviting me to your beautiful area. And now I'm going to go enjoy the sights.
June, if I could just dovetail off of Supervisor Howard's comment, not putting aside what you just said about everybody being unique in their personalities, but being your broad area of travel and witnessing different counties and policies, would there be a county or two that would have policies that kind of stood out to you as kind of the shining example of where somebody should look at for, you know, how they should form their policies or
Yeah.
take a look at?
You know what something that jumped out at me was that you don't have an employer-employee ordinance, relations ordinance, EERO. That's just one thing that jumped out at me, having that system written down in place. But again, when I talk about personalities, I'm not just talking about individuals. You know, in your county, different areas have their own personalities too, right? Organizations, your labor partners, they have their own personalities. And so, as an outsider, I'm not comfortable coming to you and telling you you need this, like an EERO, right? I got to say, you guys are probably one of the few counties that don't have an EERO. That's why I was kind of caught off guard. But
June, we actually do have an employee-employer resolution that kind of states exactly what you're saying, but it's not an ordinance. It hasn't been adopted as an ordinance. It has been adopted as a resolution by the board.
Okay, and I just did find it. So I take that back. My apologies. Oh. Okay, cool. Thank you. Thank you.
Thank you for coming up.
Thank you for your time. Appreciate the training.
Thank you very much. Okay. Take care.